All right, everyone. We welcome to our MAHRA meeting today on the good, the bad, and the ugly of, well, I think it's the previous year. Isn't that correct, Sarah?
It should be. I know my marketing person was so sweet to create this page for me, but it is of 2021. Yes. Okay. We're presenting in 2022. So I guess it could be looked at as either way.
There you go. Well, and welcome to Sara Ackermann with Rooter Wear, who is been a gracious speaker for this topic each year for us, and we are so excited to bring her back. A little bit about Sara. She sees herself as a member of a company's HR team. The clients utilize her varied background by treating her as a consultant and advisor on employment law topics. Sara counsels HR professionals on the development of proactive policies, procedures, and protocols drafted to retain talent and create a positive work environment. Sara has previous experience working inside a corporation, so she understands that myriad of employment issues that HR professionals and business owners face every day. Her focus is on providing proactive advice by identifying issues before they arise so clients can minimize their risk and avoid the expensive legal fees associated with litigation. Thank you again, Sara, for being a part of today, and I'll be your administrative assistant on the back end here with your slides and let you take it.
Yes. Away. Okay, awesome. Well, welcome everybody. I can't wait till we can do this in person. I miss seeing your smiling faces, but until then, we are going to manage through the Zoom process. I do encourage you to ask questions. Karen's going to watch for those. If you raise your hand or whatever it is you're doing to get our attention, and she'll stop me. But I would appreciate questions as we go along. That helps everybody. Maybe someone has a similar question, or it might get somebody else to think about a question on the topic that we're on. So with that, we will get started. We can go to the next slide.
All right, Sara, I don't know why it's not clicking for me. It was before.
Oh, if you go down to the bottom. I mean, I don't. You go there? There we go. Okay, so we're going to talk a little bit about COVID, which I'm so devastatingly sick of, but we'll give you a little update on some COVID related topics, talk about some fun cases. I don't have as many cases I normally would have for this presentation, just because all the courts are, and especially the Wisconsin Labor Industry Review Commission, where I get a lot of my cases, are still way backed up and behind due to COVID. So I do have some fun stuff to talk about, though I did find some, but not as many as I'm sure we'll have a lot more next year when the commission catches up. Okay, next slide. Okay, so the mandates, the ETS mandate, OSHA's mandate, dead and buried. It is gone. It is not coming back. Don't worry about that. OSHA has said, though, it is going to issue some guidance regarding pandemic safety, which they were criticized heavily for not being ready for something like COVID. They had really no specific regulations addressing pandemics in the workforce. All they have is the general duty clause that requires employers to act reasonably with safety measures, but that, according to many critics, was not enough. So for now, no ETS mandate. Of course, if you want to proceed with mandating the vaccine or choosing testing in the workplace, you certainly can. I do have clients who continued with the ETS, even though the ETS is now dead. So the FAR mandate, if you are a federal contractor, you know what this is. If you're not a federal contractor, you don't care and you don't need to care. The FAR is still alive, but is barely breathing. It is held up in the federal courts. So right now, if you're a federal contractor, you do not have to comply with the vaccine portion of that mandate, but you do have to comply with masking and social distancing and the other safety issues. The CMS, alive and kicking, you know who you are. If you're in healthcare and you're subject to that, you have been living with it for a while. So one of the $1 million questions during the ETS, which I'm just going to comment on, because in the event in the future, we do get to a level where we are mandating vaccines maybe under another regulation. This was an important question. So I had lots of clients ask me, Sara, we're under the ETS. We are allowing employees the choice between testing or vaccination. If they choose testing, can we force them to get tested outside of working hours? We had no guidance from the Department of Labor on it. My gut instinct was that the answer should be yes, You're giving the choice to employees. If they choose testing, we should be able to require them to test outside of working hours. And good news is I was right. Yay, the DOL did issue guidance right before the ETS got shut down by the courts that agreed with me that you could, in a testing situation that's voluntary, the employees choosing to test, you can require them to do it outside the workforce. Not relevant now.
On Monday. So the only 2 buildings on a different alarm system.
Somebody, I just heard some, I think we're good. So anyway, just a little comment on that was then rescinded, but in the event we have a future situation, I hope we don't. Keep in mind, if the employee is choosing testing, there's an argument they should be testing outside the workplace, working hours. Okay, next one. So what do we have going on as an aftermath, and we're still in COVID, but really the aftermath of the vaccine mandates, and those of you who are in the vaccine mandates, we have a slew at my office of religious exemption discrimination complaints. Employees who were denied a religious exemption from the vaccination are suing. We have many of these cases at Ruder Ware. I'm sure many law firms across the country are dealing with it. You know, and the case is really the employees arguing, I had a sincerely held belief. How could you deny it? And it's hard. It's really difficult to get into an employee's head. And unless you spent a lot of time grilling your employees and interviewing them about all their other things that they do in association with their religiously held belief, it's really hard to deny one. So we are seeing lots of those cases coming in with employees who were denied suing. The other onslaught of cases we are seeing are disability accommodation cases where employees are arguing they should have been allowed to work from home. They asked to work from home, they have a disability, and the employer denied them. Just a reminder that the EEOC is really pushing employers to consider work from home. If you allowed a position to be remote during the pandemic, it's very difficult for you to argue that that cannot be a remote position following the pandemic. So if you have an employee with a disability asking to work from home, you might want to try it and let them fail before you just deny it. I have a case right now where the employer only allowed the employee to work from home a couple of weeks, considered it a failure. Then they have sued, and our whole argument is whether or not that was a reasonable accommodation. Maybe we should have tried it a little longer. So careful about that. And finally, I am seeing more unreasonable refusal to rehire cases than I have ever in my career. I think we had 5 last year. Usually we'd get 1 every 5 years or few years. So I'm going to talk a little bit about that because I want everybody to be on notice that these are hot. The lawyers in our area, the plaintiff's attorneys very much now understand how this works. It's kind of a game, and I don't want you to be tripped up. So on the next slide, we'll talk about the details. So what is unreasonable refusal to rehire? It's basically a Wisconsin work comp retaliation claim. If an employee has a work comp injury and they are fired without cause, you are on the hook for 1 year of pay. If they sue and they win, which if you don't have cause, they're going to win. So what is cause? So cause is gross misconduct, stealing, violence, fighting, drunk on the job, using drugs on the job, all of those things that if you're sitting with a cup of coffee, talking to a colleague in HR, and you say, this employee did this today, everyone would agree they should be fired. There's really no argument they should be fired. That's cause. What about poor performance? Well, poor performance isn't cause necessarily. You would have to build a case for cause, giving the employee lots of written warnings, documenting exactly what they're doing wrong and and documenting that they're not improving. Eventually, you could build a case, but if you are going to terminate an employee who has a pending work comp claim for poor performance, I recommend you make sure you run that by legal counsel before you pull the trigger. Bad attitude, probably not. You would need an extraordinary case, extraordinary documentation to argue that that is cause. Again, it's possible, but it's very, very, very rare. Attendance, possibility, you could use attendance and build a case for cause, but you have to make sure you document carefully the reason and that you can show that none of the attendance issues had anything to do with the work comp illness or injury. Sometimes that's hard because the employees who are aware of this law will make it will do their best to try and tie every absence to their work comp claim. So you got to make sure you pin them down and you know exactly why they're missing work. Excuse me. What if the employee's permanent restrictions, they're on work comp, you're doing light duty, finally they reach MMI, maximum medical improvement, they have permanent restrictions, and you say, oh, we have no position for you. Can you fire them now? I don't recommend that. I recommend leaving them on unpaid leave, because if you fire them, you have an ongoing duty until that work comp claim is completely closed to notify that employee if any open positions come up that are within their restrictions and offer them that job. If they are still on the payroll as an unpaid employee, it's their duty to be working with you and watching those open positions come available. So I think there's great risk in firing someone, even if you have no work for them at the time. I would prefer you leave them on unpaid leave. I did have a client when I recommended that say, oh, but then we have lost time, which is detrimental to our work comp experience rating. So that's something you need to consider. And then if that's an issue for you that you are saying we feel comfortable terminating this employee, you just need to make darn sure you are in constant communication with them regarding positions as they come available. It's very, very tricky if you do not, and I'll go to the next slide. There's very, very tricky situations that I've had personal experience with in the last year. We'll talk about some of those. So next slide. So what if you have someone with a pending work comp claim and the claim is denied? Yay, the claim's denied, we can fire the person, right? No, not right. So in 90% of the cases, those claims are appealed. Employee gets denied, they get an attorney, they appeal. As soon as they appeal, that work comp case is revived, and so is the refusal to rehire case is revived. So make sure that you are waiting several months, if possible, before you fire someone without cause. If they filed a work comp claim, let's wait and see if they're going to appeal, because like I said, 9 times out of 10, they're going to appeal. So here's a situation we had recently. What if the employee mentions a work comp injury for the first time during the termination meeting or after they're terminated? If you fire an employee without cause, and after you terminate them or during the meeting, they say, oops, I forgot to tell you, last week I fell, I'm going to the doctor tomorrow, I would pause and make sure that you are either pause or be aware of that pending work comp claim. If they truly did have a work comp injury and they file it and it's a true work comp injury, that something happened to them at work, you want to talk to legal counsel about reversing the termination decision if you did not have cause. Because again, we had a situation this year for a client. During the termination meeting, the employee said, wait, I hurt my leg last week, I'm going to the doctor tomorrow. And the HR person said, I don't care, this decision has been made, you're being fired. And they did not have cause. They were just tired of this guy. He had some performance issues, but nothing that equaled the threshold of cause under work comp world. So HR stuck with the decision, they fired the guy. The next day he filed a work comp claim. It was a legitimate work comp claim. The IME showed, yes, he did hurt himself at work that week before. Yes, he had not reported it. Doesn't matter. He reported it eventually, and they didn't find that there was fraudulent behavior whatsoever. So the work comp claim was actionable. It's revived as URR claim, and he sued my client for a year of wages, and we settled it for about 2/3 of that amount because it was unequivocal. They did not have cause to fire him. He had a work comp injury. That means you're writing checks. So be very, very careful with anyone with a pending work comp claim. Even if it's been denied, work closely with legal counsel. Make sure you do not get tricked by this case, because all the lawyers around now know exactly what they're working with and they know the game. So any questions about that? Any questions about URR? Okay, we'll go to the next slide. This is just something for you to consider on your own time. Just remember, anytime an employee sues, they can choose one of two venues. They can choose the Equal Rights Division, which is a case under state law, or they could choose to file with the EEOC. And there are pros and cons for a plaintiff, depending on their case, that might help them determine where they file. And the procedure is a little different for each situation as well. So just this slide and the next slide, just something to use in the future if you get a claim and you want a little bit more information about the difference between the ERD and the EEOC. So I'm not going to go through it in detail. Next slide. Next. Okay, ADA and FMLA. We're still getting a lot of questions about the difference between ADA and FMLA, and it is very confusing because they frequently overlap. So we'll go to the first slide. I'll talk about some common issues. So remember, the Family Medical Leave Act is leave. It is not accommodation. It is leave. I can't work. I have a serious health condition. I need leave. There's no magic words with FMLA. If you know I have a health condition and you know I'm missing work, you need to give me the paperwork. I don't have to say a darn thing. Nothing has to come out of my mouth. So even if I just say to my supervisor, oh, I'm so depressed, I'm going through a divorce, I can't sleep at night, that's why I'm coming in late. Boom. That's enough to trigger the FMLA paperwork. I might have depression, I might have anxiety, I'm indicating that I have a health condition that's affecting my ability to do the job. That is where you need to give me the FMLA paperwork, put me on notice that I have the ability to apply for FMLA, if I'm eligible, obviously. And again, as we know, FMLA leave can be intermittent. This is very frustrating because that might mean if I have migraines, for example, my healthcare provider may say, Sarah needs to take time off whenever she gets a migraine. We estimate a migraine to occur twice a month, 2 days at a time. Basically, I call in that day and say, I have a migraine, I can't work, and you have to give that leave to me. It's very frustrating. Management doesn't like it. You need to educate management that unfortunately there is no hardship argument. You just have to burn my intermittent leave until I get rid of it. You got to put up with it. Reinstatement is protected. After FMLA, I am guaranteed my job or a job very, very similar to my job. Same duties, similar title, similar pay and benefits. Americans with Disabilities Act and state law. This is a disability. First of all, I have to have a disability to be protected under the ADA. And I get an accommodation. This might be leave, but it could be a whole host of other things. I need to work from home. I need a special desk. I need to take breaks. I need a different schedule. So ADA is a little more complicated really than FMLA because you need to work with the employee to figure out what accommodation do they need, what accommodation can we provide. Sporadic intermittent attendance is not a reasonable accommodation under ADA. So once you burn FMLA, if you have the employee that is still sporadically missing work, you might be able to build a case for undue hardship. Now, you can't just assume it's undue hardship. You need to build a case. But you then, if you have that case, you could deny that leave. Next slide. So here's some common questions. We have an employee who's exempt. They request intermittent FMLA leave. How do you pay me? How do you pay her? You can deduct from pay during FMLA. This is one of the rare exceptions under the exemption rule for deduction from pay for an exempt employee. You can deduct from pay for leave I take that is FMLA leave. So for intermittent leave, the easiest way is usually to make me hourly. Let's say the doctor says I'm gonna need intermittent leave the next 6 months for my migraines. Make me hourly for the next 6 months. And so then you can easily decide what hours I'm working and decide what my pay would be at the end of a work week. What if the employee is exempt, runs out of FMLA leave, and still needs intermittent leave under the ADA? How do you pay her? Well, even though FMLA is expired and you technically can't deduct from my pay, you still treat it the same way. You can still keep me hourly, figure out what my hourly pay is, and pay me for the hours I am working. Alternatively, you can just reduce my pay on a weekly basis based on how much time I'm able to work. So if you know I'm limited to a 30-hour work week and I used to work a 40-hour work week, you just reduce my pay going forward on a percentage basis. That gets more complicated though if my leave is sporadic and you're not exactly sure when I'm going to be gone in a week. So if you're not exactly sure when I'm going to be gone in a week, you'd want to make me hourly. Next slide. What if an employee is requesting FMLA as an accommodation to work from home? Do we have to grant this? No, FMLA is not accommodation. FMLA is leave. However, if the healthcare provider says the employee needs intermittent leave, and when they can work, they have to work from home, then you have two issues going on at once. You have the right to the FMLA paperwork that says they need intermittent leave first, and then you have the right to ADA paperwork that pins the doctor down on why the employee, when they can work, why can't they come into the office? Why do they have to be at home? So you're dealing with two sets of paperwork. It can be very burdensome, but you do want two sets of paperwork because the ADA allows you to gather way more information about the accommodation. Whereas with the FMLA, you are stuck with the medical certification form, which doesn't talk about accommodation at all. So you will need to work with basically two different separate inquiries in order to see if you can accommodate the employee. In drafting tips, I just make a note there. For the accommodation forms, you want those tailored. There's really no way to draft a form to use in every situation. I mean, I've seen some good forms like out there that people have gotten from MAHRA or maybe SHRM, but in a perfect world, you want to have a tailored form. You know, here's employee's job, attaches her job description. She's requested to work from home. We think we can give her breaks. We think that we can allow her to have a couch in her office. We're not sure why she needs to work from home. Please explain. So you really want to pin the doctor down on the specific accommodation the employee is seeking. So that's why I recommend a tailored form each time. Next slide. Here is a huge one. This is very common. Employee says, I can't work overtime due to a serious health condition. I can only work 40 hours a week. See this all the time. Is this an ADA or FMLA? Well, if the employee is eligible for FMLA, it's definitely FMLA because they're asking for leave. They're saying, I can't work 48 hours this week of the mandatory overtime. I can only work 40. So in weeks that I am scheduled to work overtime, you can count that overtime against my FMLA because I'm asking for leave. I can't work that extra 8 hours. So you want to do that so you're burning down my FMLA eligibility and tracking it. And actually, you need to do it because you need to track FMLA under the law. I don't have a choice. I don't get to say, no, don't count it as FMLA. I have a serious health condition. I can't work. That's leave. That's FMLA. It needs to be tracked. Once that's exhausted and FMLA is gone, then you have to decide, can we still accommodate that? Can we still accommodate Sarah not working mandatory overtime? And that's a case-by-case basis. You need to build hardship, and you can track the hardship during FMLA because you have to give me the FMLA. So if during FMLA, employees are complaining, employees are overwhelmed, you had to hire temps, you had to do all these crazy things to accommodate my FMLA leave, that might build your case for undue hardship. Next slide. So this is what I'm talking about. Unpredictable attendance. Is that ever an essential function of the job? Yes, it is an essential function of the job. However, while modification of schedules and attendance requirements is a reasonable accommodation, sporadic attendance is not. The EEOC has specifically said this. ADA is not FMLA. So you got to get through FMLA and then build your case that this attendance issue cannot be tolerated. It's now undue hardship. Next slide. Talk a little bit more about that. So what do we have to show with ADA and sporadic attendance? So if the employees burnt their FMLA off and they still can't return to work full time, they still need intermittent leave, do you have to grant it? Not if you can show undue hardship. What are some examples? You can show that you don't have a sufficient number of employees to do the job. What if this employee is the receptionist and it's the only one you have? And every time she calls in sick, you're scrambling to cover. That would be really good evidence of undue hardship. Failure to meet work goals or to serve customers or clients adequately, a need to shift work to other employees, incurring significant costs, whether other employees are forced to work overtime, or when temporary workers have to be hired to cover. Track this during FMLA. While you're forced to deal with this during FMLA, track all of these things that are on undue hardship, so then you can build your case that you don't have to continue this after FMLA. Next slide. This is just an example. Brad has asthma. He's not eligible for FMLA leave. He works on an assembly line shift that begins at 7. Recently, his illness has worsened and his doctor has been unable to control his breathing difficulties. As a result of these difficulties, he has taken 12 days of leave in the past 2 months, usually 1 to 2 day increments. The severe symptoms generally occur at night, requiring Brad to call in sick early the next morning. Lack of notice puts a strain on the employer because the assembly line cannot function without everyone present. There's no time to replace him. So they're scrambling every morning that he calls in. Next slide. So the company in this situation seeks medical documentation from Brad's doctor about his absences and whether or not this frequency is going to continue. That's what I'm talking about, the tailored accommodation form. The doctor says, we're doing everything we can. We cannot find an answer. There's no way to predict when these symptoms are going to flare up. And we don't see any change in the foreseeable future. So given Brad's job and the consequences of being unable to plan for his shift, the company determines they cannot keep him on this shift. There's no additional position open that's available for him. He can be fired. But look at all the angles we had to go through. We have to make sure, A, how long is this frequency going to continue? And once we know that it's indefinite, then 2, can we show it's an undue hardship? Yes, we can. So be very careful before you just, after FMLA, cut the cord and fire somebody. You need to go through this process and document it to make sure you don't open yourself up for an ADA claim. Next slide. I'm gonna skip over this one. Next slide. You guys can read this example on your own. So one case we had this year that was good for employers was Potts versus the state of Wisconsin Department of Health and Human Services. So this employee sought a 6-month leave of absence due to her mental disability. And the employee said, look, just move me to one of these open positions. You have a ton of open positions and I'm qualified to do that. So just move me to one of these and bounce me around between open position to open position during my 6 months leave. And when I'm ready to come back, we'll see what's open and what I can do. And Labor Industry Review Commission said, look, finding a new job into which the complainant might be transferred while allowing her to remain on leave lasting 6 months or more was not a reasonable accommodation, nor was it one that respondent could provide without showing undue hardship. However, be careful, because if you do have an employee who needs a long leave of absence and there's an open position that you could put her in that will not create an undue hardship, you do need to consider it. So in this case, they did consider it and they said, wow, this is just not going to make sense, moving open position to open position to open position, because these positions are not, they're not open for very long. So it doesn't make sense to move her around during this leave. That was an undue hardship for them. But if you have 5 open positions and you can't hire, because right now that's possible, it's difficult to hire, and you're going to have these 5 open positions and it's not an undue hardship to just throw me into one while I'm on leave, you need to consider that. How is that a hardship? So give me one of those open positions while I'm on leave. You have 4 other ones open. It's not a hardship. But if you fill them all and you're trying to fill them and you can fill them with an open, with a candidate, you're not required to hold the job open. But if you have 5 and they're open, how is that undue hardship? So just be very careful before you deny a reassignment, and you make sure that you consider reassignment as an accommodation. Next slide. This is just what I say every time, interactive process is so important to be able to show. If you do get a complaint from an employee, you want to be able to show you engaged in this and it is in writing. Emails are fine. Just so you have documentation that you reviewed. What did the employee request? What did the employee's doctor say? What did the employee want? Did you discuss all of this with the employee? Sometimes we miss that part. We get the note from the doctor. We just say, oh, we can't do this. Accommodation request denied. You got to go back to the employee and say, hey, here's what your doctor said. We can't do this. Do you have any other ideas? Do you want to go back to your doctor and think of something else? Because we can't allow this position to be worked. You can't work from home. Here's all the reasons why. What else is there? So you need to show that back and forth. Are there other alternatives? Again, document, document, document. Don't make assumptions. Never say never. Better to let the accommodation be, try it and let them fail. Then you can tell the EOC, look, we tried it. We tried it for 30 days. This did not work. The employee could not perform the job, versus saying, oh, we know it's not going to work. Well, how do you know? You didn't try it. So this is a very frustrating area of law. Before COVID, this was our biggest area of law, reasonable accommodation cases. Now, like I said before, we're still seeing those. We're seeing the religious accommodation cases as well. But this is still a very hotly litigated area, so you want to be careful. Next slide. So race and sex discrimination. Next slide. This is a new area of law. I entitled this DEI Not So Fast. So in this case, last year, this is a 2021 case, David Duval, he's a marketing VP. He sued his employer after he was fired. He alleged that they fired him and 7 other white males as part of a push to move towards diversity and inclusion. They had a big rollout of a new DEI policy, DEI training. And so he was convinced, in an effort to become more diverse, he and 7 other white males got fired. He could show he was replaced. His job was replaced him with a white female and a Black female who shared his former job duties. He was fired just 5 days before his 5-year anniversary. And he could show in the file, he had positive performance evaluations every year. Now, they argued he was a bad employee, he had poor performance, that there was no documentation. All he had to show was his positive employee reviews, which were very, very bad for the company. So he sued under Title VII and he got a $10 million jury award. Now that's going to be remitted because under Title VII, we can't get $10 million. But the point here is, white males are in a protected class, and we forget about that. And 5 years ago, we didn't have cases where white males were suing for being a white male and being discriminated against. It just didn't happen. Now, I personally had a case within the last 3 months, which was a white male case. I was treated differently than a woman. I got fired, she didn't. So it's obviously, I mean, it's a legitimate claim. It has always been, but we just haven't seen much of it. So now when we're all looking at our workforces, we're trying to be more diverse, we're trying to be more inclusive, we're trying to make sure we are recruiting to be, to get a diverse workforce. We still need to be mindful of the fact that everyone's in a protected class. So we need to treat everyone similarly. And in this case, I say what errors were made. Look at the file. He's been there 5 years. He's a very high level employee. There's nothing in the file to support the termination. So all he has to show is he is replaced by someone outside his class and he wins. It's not rocket science. So be very, very mindful of, whenever you're doing a termination, do you have sufficient documentation? Otherwise, these juries do not like you. Juries will not like you, and litigation can be very painful. Next slide. Here's a case, very interesting Wisconsin case regarding pregnancy. Andrea Musato, she was hired and she works 60 days for this employer. Exceptional Minds does criminal background checks on new hires, but for some reason, they didn't do one on her. So I'm not sure why. The case doesn't explain if they just forgot or how this happened, but she's hired. Everything's going great. She's working for 60 days. She tells her supervisor she's pregnant. For some reason, they then do the criminal background check. Again, I don't know why that prompted them to do it, or they started digging into her background, maybe for other reasons that weren't disclosed in the case. But in any event, she says she's pregnant. They do a criminal background check. They find out she has a conviction that's been expunged. So she had not disclosed this conviction on her job application because it was expunged. So she didn't think she had to disclose it. They thought she did. They fired her for not disclosing it. This is why this case is interesting. Labor Industry Review Commission says, look, she's right. The law in Wisconsin is that an employee does not need to disclose, or any applicant for anything, except for some healthcare, there's the healthcare workers, but she was not required on that form to write down the conviction. It was expunged. That's a legal clean slate. She was correct. She did not have to do it. However, it believed AM's reasoning. So while it might be unfair to discharge an employee for failing to disclose an expunged record, the question is whether the action was taken due to her pregnancy, and it wasn't. The action was taken because she, in their opinion, lied on the application form. So she doesn't win a pregnancy discrimination case. However, if I were her attorney, I would now file a public policy discharge violation. As we all know in Wisconsin, even though everyone's at will, you can't be fired in violation of public policy, because she was following the law and not answering that question. I think that she has a public policy argument. So that would be my reasoning. But in any case, remember, whatever is going on in your head, whatever the reason is for termination, that's the reason you're stuck with through litigation. And here it actually helped them. They could show it had nothing to do with pregnancy. Might be the wrong reason, might be unfair, but it had nothing to do with pregnancy. Next question, next slide. So arrest and conviction, again, my favorite area of Wisconsin law, probably my client's least favorite area of Wisconsin law. It's super frustrating, but the cases are very fascinating. As a reminder, under Wisconsin law, you can only terminate an employee who has a conviction if the conviction is substantially related to the job. And if they have a pending charge, you can never terminate me. You can only suspend me if the pending charge is substantially related to the job. So just a reminder. Next slide. So this is an interesting case from from last year's, actually, I should say 2021. CODA and CODA versus the Oconomowoc Area School District. So these brothers worked for the district, and they did grounds work, facilities, janitorial services, and part of their job included taking the district's recycling, like recycling cans, bottles, and taking that to turning that in for money that the district, obviously, they would get the money and they'd give it back to the district. So in 2014, there were some allegations that the CODAs had actually taken recycling and kept the money, didn't give it all back to the district. They took the recycling into the recycling vendor and kept the money that they received. Now, what complicates things is they had their own personal lawn business and their own personal recycling business. So they could argue, well, some of this we did make money, but it was because of the recycling we took out of our own business, nothing to do with the district. So, however, they were not supposed to use, and they knew this, they were not supposed to use the district vehicles for their own personal business. So anyway, there was a big investigation. The allegations were both that they took money and they used district vehicles for their personal business. So during the investigation, the brothers denied taking any money, but they did admit on occasion they couldn't deny that they used the district vehicles for their personal business. So they admitted that. The district's investigation revealed over $5,000 in missing money. They could never tie that to the CODAs, and the CODAs denied. However, for the vehicle issue, they each were suspended 3 days. So the district said, look, you admitted to this, you're getting suspended, end of story. So after this, the district turns the case over to the police department. They said, look, we have $5,000 missing. We can't figure it out. You guys help us. So they started an investigation, and they ended up charging each of the CODA brothers with theft. The district then places the CODA brothers on unpaid suspension, which you can do. They have pending charges for theft. Theft is substantially related to the job, unpaid suspension, just fine. Then in 2016, the theft charges are dismissed. No more pending charge, no more conviction. Guess what they have to do? Rehire them. That's not what happened. So in exchange for the dismissal, the CODAs each agreed to pay $500. There's no conviction. Next slide. So then the district, like I said, they fire the CODAs. This is bad. They have no reason. There's no conviction. There's no pending charge. The termination notice says, now the district has learned you were in fact guilty of theft of funds from the school district, which you denied in 2014. So CODA sued for arrest discrimination, and I don't blame them, because Lurk in their decision explains the law very well. If the district's discharge was based on its own internal investigation that results in a finding a policy violation, then arrest discrimination has not occurred. However, the district was not persuaded that the complainants engaged in theft until they learned from the prosecutor. The prosecutor believed that they were lying. And the prosecutor believed they were guilty, but the prosecutor didn't prosecute them. He took a deal. A deal is not a conviction. So because the district fired them, if they would have fired them back 2 years prior as a result of their ongoing investigation, no problem. You have the right to fire people who violate company policy, but you can't fire people based on a criminal record or what the police are doing. So that is a very big difference, and this case explains it very well. So because the decision was terminated solely based on the arrest record, which is illegal, you can't do anything on the basis of arrests, right? They win. So 5 years of back pay, $80,000 in attorney's fees. Next slide. This is a case that is still going on. It's I talked about it last year, but I'm just going to touch on it again. This is Palmer versus Cree. Derek Palmer applied for a lighting specialist position. On the application, he checked yes to conviction and he wrote domestic related. And the offer was made conditioned on a background check. The background check reveals he had criminal damage to property, battery, strangulation and suffocation, and 4th-degree sexual assault, all arising out of this domestic related incident. So he didn't necessarily lie on the form, and they didn't find that he lied on the form. But what they were very worried about was the fact that he worked around women and he had a strangulation and 4th-degree sexual assault charge, or conviction, basically. So they took the offer away. They're saying, look, he might work with women. We don't like this. This is related to the job. We're revoking the offer. And he sued for conviction discrimination. And initially, the Equal Rights Division agreed with his employer and said, look, I can find, initially the ERD said, no, we agree with him. This is not substantially related. We're finding probable cause for discrimination. Then there's a hearing and the judge dismissed the case, finding no discrimination. Next slide. So Palmer appealed to the Labor Industry Review Commission. The Labor Industry Review Commission said, look, the conviction has to be substantially related to the job. In battery cases, substantially related can be established if the employee is working with vulnerable populations. Here, he's not working with any vulnerable population. So the battery conviction is not substantially related. Regarding the sexual assault conviction, Lurk found no substantial relationship because the assault was domestic. Domestic means wife, girlfriend, lover. Next slide. So Lurk overturned the win and now gave the win back to, or overturned the judge's dismissal, gave the win back to Palmer. And this is really important because I get this a lot with sexual assault cases. And the employer always wants to say, look, women are everywhere. He's working with women. That is not enough if it's a domestic related sexual assault. And here's what Lurk says. The fact that there are female employees in the plant with whom the complainant could potentially become involved in a personal relationship that might end badly is a scenario requiring a high degree of speculation and conjecture, and one that goes well beyond any reasonable concern about job-related conduct. And it goes on to say that this is not enough just because women work around him in the workplace. Next slide. So the Lurk reverses and gives the win back to Palmer. And they award him, from going back from 2015, full back pay, attorney's fees, and all vacation benefits, everything he would have earned since he sued. So now he appeals to the Racine County judge. The Racine County judge reverses Lurk. Palmer appeals to the Wisconsin Court of Appeals. Last year, the Wisconsin Court of Appeals agreed with Lurk, win back to Palmer. He's now winning again, reinstates all that he won. And the case was then appealed to the Wisconsin Supreme Court. And the case is still pending. So we check it every week. And oral arguments were in October. We haven't heard a decision. I can't imagine that the Supreme Court's going to argue any differently or rule any differently, because my understanding of the law is that this domestic assault case is not related to the job unless he's working with his wife, working with his girlfriend, working with his lover. And none of those situations are present here. However, we are going to watch this closely. So when we do get a decision, we will let you all know, because if they change the way they look at this type of a case, it's going to be really altering the landscape of arrest and conviction law in the state of Wisconsin. So we're going to keep an eye on it. Any questions? I'm going to talk a little bit about non-competes. Any questions about any of the discrimination cases I talked about? Any of the ADA, FMLA stuff, arrest and conviction? Anyone? Okay. So I want to talk a little bit about non-compete and the remote workforce. So next slide. If you have non-competes in Wisconsin, we use the term non-compete loosely. There are actually 4 types of non-competes, and the legal term is restrictive covenant. So the 4 types of restrictive covenants we see in Wisconsin: non-compete, don't work for anyone else. That's a true restriction on employment. We don't want you working for a competitor. A non-solicitation for customers, don't steal our customers. We see these all the time. No contact with customers after you leave our employment. Non-solicitation employee, don't steal my employees. Don't contact and don't steal our employees away after you leave employment. And finally, non-disclosure. Don't steal our confidential information. Don't steal our secrets. Hint, judges are not fond of the first one. Judges in Wisconsin do not like, and in many states, do not like non-competes that restrict an ability to work. They just don't. So they're under a very high intense amount of scrutiny when you do draft one. Next slide. So for all 4 of these are agreements. These are contracts. They do not belong in your handbook. They belong on a separate sheet of paper that you sign and the employee signs. If you want them to be enforceable after employee leaves, they have to be in a contract form. So separate signed agreement, not in the handbook. And to be enforceable, you need to have an offer, an acceptance, and consideration. So that's the basic contract principles of contract law. So you have to give me something. I have to agree to do something in exchange for what you give me. So we have continued employment, a job offer, or money are very common things that you give an employee in exchange for having them sign one of these types of non-competes. Next slide. So in Wisconsin, we have a statute, and all of these are needed for any type of restrictive covenant. You have to show a territory restriction, you have to show a time restriction, you have to show a duties restriction, you have to show it's necessary to protect the employer. And spite is not a reason, and I bring this up because I'm a huge Seinfeld fan, and I don't know if any of you remember this episode, but Jerry bought a jacket, and he tried to return the jacket, and he didn't have a reason, and they said they couldn't accept the reason. They couldn't accept the return without a reason, and then he said, well, my reason is spite. And they said, I'm sorry, sir, we can't accept a return for spite. Spite is not a valid reason for returning the jacket. So I've always thought that was funny. So spite is not a reason. The fact that you're mad at the employee, and even the fact that maybe you spent a lot of time and money in training the employee, that is not a reason to enforce a non-compete agreement. You have to show it's going to hurt me, that it's going to hurt you. If I leave and work for a competitor, not just that you're mad and you spent a bunch of money and I left, but that I can hurt you working for this competitor. And it can be unduly harsh or oppressive to the employee. So all 5 of these things have to be shown if you want to enforce a non-compete agreement. Next slide. So with respect to time, in Wisconsin, we feel real comfortable with respect to a time frame of 18 to 24 months. I like 18 months just because 24 judges get, that's on the outskirts of the limit that is frequently upheld in the state of Wisconsin. So I like 18 months. I have clients who say, look, put 24 months in there and then we can always negotiate down to 18. Depends on how much you want to mess around with negotiating, but definitely we know within that time frame, you should be pretty safe. Keep in mind, I am not talking about non-competes associated with a sale of business. So if you run a salon and you sell your salon to another person and you have a non-compete that says, you're going to agree after you sell your salon, you're agreeing that to the seller, you're not going to start up a salon across the street. That's not the type of non-compete we're talking about. Non-competes related to the sale of business. The statute does not apply. You routinely can see and non-competes that go 5, 10 years even with respect to the sale of a business. So we're not talking about that. We're just talking about employment. Next slide. So what is consideration? You have to give me something. You have to give me something if you want me to agree to non-compete. So an offer of employment, the cleanest way to do it. You don't get the job unless you sign this non-compete, all right? That's very clean. Money, here's $500. You don't get it if you don't sign the non-compete. A promotion. A contract. If I'm an at-will employee and now you're going to give me a contract with severance if you fire me without cause, that's consideration. That's something I didn't have before. What about continued employment? Here's the problem with continued employment. It is definitely adequate consideration. We now have a law in Wisconsin that says continued employment is adequate consideration. But there are issues with that. Next slide. So if you present me, and let's say Bob is my coworker, and you're going to require me and Bob, we've been with you for 2 years. And now you're going to say, look, if you want to continue working here, Sarah and Bob, you each have to sign this non-compete. And I say, no. Are you going to fire me? Because that's the remedy. If you don't fire me, if I refuse, and Bob signs it, Bob's like, okay, I'll sign. And Bob signs and I refuse. If you do not fire me, his consideration just disappeared. His consideration became what we call illusory. It's not real because you didn't fire me. So really, if I get to continue to work and he had to sign it, if he ever found out that I didn't sign it, and if there's litigation, his attorney's going to find out, then you just lost your ability to enforce the non-compete against Bob. So are you really prepared to fire everyone? So it might be better if you're not, if you say, look, if Sarah refuses, we got to keep her. Might be better not to use continued employment and use money or something else that's tangible if you want to make sure you have the argument against Bob. So would you really fire? And we just, this month, I had a case and Nicole had a case with a client where they wanted to use continued employment and we warned them, and some key employees in both of our situations didn't refuse to sign, and they were not prepared to fire them. So we're in between a rock and a hard place with two different clients who just assumed that these people would sign, and in both cases they had an employee refuse. So it's very risky to rely on continued employment. Next slide. So what are the biggest mistakes we see with non-competes? Not complying with the janitor rule. In Wisconsin, we have a very clear janitor rule, and it's based on a case involving where the court used the term the janitor rule. So what does that mean? You can't prevent me if I have a non-compete. You have to limit the non-compete to the duties I did for you. So if I was a COO for you, you can restrict me from working as a COO for a competitor. But if I just wanted to go be a janitor for the competitor, how does that hurt you? It doesn't hurt you. Or a receptionist, or I want to do a completely different job for the competitor. That can't hurt you, so you have to allow me to do it. So the non-compete has to be structured to only be tailored to what I did for you. So that's a very big error. We still see draft non-competes that don't comply with the janitor rule that would be unenforceable in Wisconsin. Not tailoring the territory for both the competitor and the employee. There's no consideration, or the consideration isn't clear. You need to have the consideration in the document. The length is too long and no one can understand it. So if I read a non-compete, and I'm an attorney, I've been doing this almost 20 years, if I have to read it more than once to figure out what the employee can and cannot do, it's going to be really hard to convince a judge that's enforceable because it's too complicated. So you want to make sure your language is very clear and concise, and there's not a bunch of legal mumbo jumbo in there that no one understands. The other biggest mistake we see now is it doesn't work with the remote workforce. Next slide. So let's assume John signs a non-compete with ABC Bank, and he signs it at the beginning of employment. No problem, we have consideration. The provision says John agrees for a period of 12 months after his separation from employment with ABC Bank for any reason. He will not perform commercial loan activities for any other bank within a 60-mile radius of ABC Bank. Okay, what is wrong with this? 12 months is good. We followed the janitor rule because we're saying he can't be a commercial loan banker. What's wrong with this? Next slide. It doesn't work with remote workforce. So look at the language and then look at the scenarios. John moves 70 miles away to Eau Claire. He starts working remotely from his new apartment. He's in Eau Claire. He's 70 miles away, so he's outside the 60-mile radius, but he's working for a bank that is right across the street from his old bank. So his old bank is like, what's going on? He's employed, he's working remotely. Arguably in our world. He's still in Wausau. He's not physically here. So he's complying with the non-compete, but he is arguably doing what they don't want him to do because he's in Wausau. Also, what if the second scenario, John stays in Wausau, he starts working for XYZ Bank 70 miles away in Eau Claire. So he's still in Wausau, but he's not working in Wausau. He's working remotely for a bank outside the 60-mile radius. So technically he's not in violation of this clause because the bank is outside the 60-mile radius, even though he's doing work in Wausau for the bank. He's arguing, look, the competitor is not within the 60 miles. So here are the issue. This clause would have been very clear 5, 6, 7 years ago when no one was working remotely. But now it's very unclear what he can and cannot do. Next slide. So how do we draft an enforceable non-compete for the remote worker? Where is the competitor located? We need to define that territory. Where is the employee located? Can they work from anywhere in the world? Let's evaluate what they can do, how they can do it remotely. What territory do we want to restrict them to? Cookie cutter non-competes are out the window these days. We recommend now for every new employee you want to bind to a non-compete, it should be tailored. And that's an administrative nightmare. But if you really want to enforce these things, you can't just have a fill in the blank non-compete. So in our opinion, you need tailored agreements. And one idea is to list the competitors you don't want me working for. That's an idea. Now, those might change and you're stuck with the list. But in any event, with a new remote workforce, strongly recommend you revise your non-competes. If you need help, we're happy to help you. But just keep in mind that with the remote workforce, it's very difficult, very, very difficult to enforce these things if you don't tailor them. So we're almost out of time. I will just leave it there. And if anyone has any questions, we have a couple more minutes. And if you have any questions about anything I talked about, please email me. There's no charge for follow-up questions regarding the presentation. I'm happy to answer any questions arising out of the presentation that you had. And obviously, I love to connect with you after. I'm sorry I can't be there. It's too bad we can't all be together in person. But I really appreciate the opportunity to present to you today.
Thank you, Sarah. I think that you have brought a lot of information to us, and how has times changed? Wow, with this
right.
Remote workforce is just, it's another beast. I know that our businesses are all dealing with. You all can, if you still have some questions, you can throw them in the chat, Sarah, if you want to just stay on, and I think you'll be able to see those. I have just a few follow-up things for the group right now. If you are interested, we do have a couple of things that businesses can be involved in coming up on March 8th. I am looking for some businesses that would be interested in allowing the Auburn about 50 students and chaperones from Auburndale to tour their businesses, learn more about careers and those businesses. They also need a place to kind of sit down for lunch, and they will be bringing their lunch. They just need a place to sit. So if you are open to allowing them to come in to do a tour in your business and learn more about careers with it, please reach out to me. The next thing is on Tuesday, April 19th, we are holding the reality stores. This has been kind of in a hiatus for the past 2 years. Therefore, I am looking for businesses that want to be involved in that. We are going to do it all in the one day. We have about 500 students that will be going through the reality store. So we're holding them on the UWSP and MSTC campuses here in Marshfield. You can do half-day shifts or full-day shifts with that. Most of the information is already prepared for you. So it's a pretty easy volunteer activity, and you get to meet with the students, which is kind of a cool day of them going through and learning how to balance a budget. So, and then the last thing is we had this thing ready to launch in 2020. And of course, we all know what happened in about March of that year. So we had to cancel this event, but we are launching it now. And that's the Marshfield Area Career Expo. And this is where about 500 high school sophomores will be going through the 16 career clusters and learning about hands-on type activities of careers and activities that surround them that will help them to kind of help guide them into some ideas of what their future could look like in these types of careers. That again will be held on April 29th at the UWSP and MSTC campuses here in Marshfield. If you can't participate in an interactive booth or volunteer, I mean, we need people to help guide the students off and on the bus, kind of guide them around where the campuses are, get them from one campus to the next, as well as we do feed you on both of these events that I've mentioned. So come, we'll make sure that you're fed and have lunch. And but there is sponsorship opportunities available for that too, to get your business name out there. The bags that we have planned for each one of the students, you're welcome to have something about your business in that bag as well. And the final thing is we are in the midst of recruiting for youth apprenticeship and summer jobs and that. So don't forget to get those things out on our job board. The schools are utilizing that job board quite readily. And I just keep as soon as a new job gets posted up that qualifies under one of those two, I'm pushing them out to the schools and going from there. Remember the job board, because you're a chamber member, that is free for you to utilize and post on. Last thing is our next meeting is March 16th. It will be held here at the chamber. Karen Olson, our business development director, will be giving you a local economic development update for the community and talk about the projects that are in the works, housing, things that we are facing. I believe they might be touching a little bit on child care initiatives in the area, and feel free to come here. This will be back at our normal time of 8 to 9:30 in the morning, depending on how long that presentation goes. And we'll have some breakfast snacks and that available for you, as well as we'll make sure the coffee's flowing. So, so if anybody had some thoughts and things like that for Sara, please feel free to speak now.
Mm-hmm.
And crickets.
I must have just did such a great job. There's no question.
You are amazing, Sara. Well, thank you, Sara, again, for making time out of your day today. I hope that Daytona goes well and that you have enjoyed the sun. Oop, I have a hand raised and I can't see where it is. Lynn.
That was me. It was actually meant to be a clap.
Oh, that is.
Oh, yay. Well, I'll take that. I'll take that. Great. Well, thank you. Thanks, everybody.
Thank you all. Have a great day.
Have a great day. Thanks a lot, Karen.